Hi, I'm Evan Aidman, and I want to talk to you today a little bit about the mediation process. Mediation is a completely voluntary procedure that is frequently used to resolve personal injury cases or any other kind of dispute. And we have to distinguish it from binding procedures, such as the binding arbitration or the binding high-low, where you come out with a decision and everybody is more or less stuck with it. In mediation, you get a mediator who tries to help the parties settle the case, and if at the end of the day you're not happy with what the mediator's recommending or what the insurance company's offering, you walk away. But mediations frequently lead to settlements, and they're very, very important. And as a plaintiff, you should generally rejoice when the defense agrees to mediate a dispute, because many times the cases are settled then and there. Now, sometimes insurance companies propose mediation not because they want to settle the case, but because they want to dig. They want to gather information. They want to see the plaintiff. They want to see what the plaintiff's lawyer has to say. And they're not serious that day. They're just gathering information. But that's okay too, because especially if you've got a good case and a good client, you want the insurance company to see that, and at least you're going to learn some things yourself. It's a good thing. It's a good use of time. But many cases do get settled then and there, and insurance companies typically don't want to spend the time and money on a mediation unless they're serious about settling. You have to be willing, though, to walk away, because a lot of the mediators are going to try to push a settlement that's maybe a little below what the case is really worth, or maybe a lot below. The mediator may be getting a lot more work from the insurance company and be making a lot more money from the insurance company than from the average plaintiff's lawyer, and so the mediator may be more tied to the insurance company. So you've got to be willing to say to the mediator, you're just flat off base on value on this case, and we're just not going to take it. It's an important process. I generally agree to just about any mediator the defense proposes. Now, if it's a binding arbitration, it's a whole different story. Then I want somebody I absolutely know is going to give at least a fair shake, if not be leaning towards me. But for a mediation, I don't really care that much, because I can walk away from it. And if the insurance company proposes a mediator, I'm generally fine with it. I just say, look, this is somebody you proposed, and look, this mediator's proposing that you settle this case for a lot of money, and it's your guy. So that's pretty persuasive with insurance companies. Any questions about this process, send me an email, evan@legalaidman.com.